A Florida judge striking down the state's updated Stand Your Ground law. Now, the changes aim to further protect those who respond to threats with deadly force, but critics argued that it would make convicting violent criminals more difficult. You'll remember, this law received national attention when George Zimmerman used it to successfully claim self-defense in the fatal shooting of Trayvon Martin back in 2012. Joining me now is Philip Holloway, former Assistant Attorney General, former U.S. Navy Judge Advocate General, and legal advisor to Georgia Sheriff's Department, and also Wendy Patrick, a veteran prosecutor and trial attorney, to discuss this. The Stand Your Ground law really came into national attention during the Zimmerman trial, and that's what people are most familiar with. But in the wake of that, gun rights supporters had actually pushed for revisions to the law. They wanted things to make it a little bit easier to disprove a defendant's self-defense case during pretrial hearings. They wanted prosecutors to have that requirement, and they were disappointed by the judge's ruling. So just to kick things off, Philip, how do you feel about the judge's ruling?
Well, first of all, I find it difficult to believe that this judge was not absent from law school the day they actually taught law in law school. This decision has absolutely nothing to do with any constitutional principle. Basically, what the judge is saying is he's saying that, look, I think that the state Supreme Court should be the one that decides rules of criminal procedure and not the state legislature. And that is probably the most moronic thing I've ever heard a judge say. And we could really talk for an entire segment about why the Zimmerman trial was not about the Stand Your Ground law. It really wasn't. It was about traditional self-defense. The two things generally get mixed up, not only in the media but in the general public. But this case was limited to the facts of this specific case in Miami. Any other judge in Florida is free to interpret the law in any other way, so it is not accurate to say that the law was struck down. It is very much still in force. This ruling will be taken up on appeal, and that is where these issues will be decided. And I predict with a very high degree of confidence that this judge will be reversed on appeal.
Wendy, I want to bring you in, but Philip, you actually mentioned this, so we might as well read it. Judge Milton Hirsch in his ruling, this is what he said. He said, as a matter of constitutional separation of powers, that procedure cannot be legislatively modified. So he does make that argument, the separation of power argument. Wendy, your thoughts?
Yeah, I got to tell you, this is a very controversial law. It's much more than shoot first. That is one of the reasons it's so controversial, is there's a lot to it. It's got to be a reasonable belief that one's life is being endangered and that deadly force is necessary. The ruling yesterday was not about the merits, but the method. The separation of powers argument really goes like this. They said the legislature determines substance and the courts determine procedure. Shifting the burden of proof is procedural. That was the court's argument. But no doubt anticipating a lot of the pushback, you heard some from Philip, you've heard it from other places, you're hearing a lot of it that just happened yesterday, is because there's a 14-page ruling really justifying why the court came to the decision that it did. Now, we still have this law in Florida, but determining how it moves forward, obviously that's going to be through the court system for now, not through the legislature.
Yeah, and political will really does matter, and particularly in these issues. This type of issue is such a hot-button topic. Florida Governor Rick Scott signed the amended legislation. It was backed by the National Rifle Association. Florida lawmakers essentially were responding to what they heard from their constituents. But here's something that was said by Florida Governor Jeb Bush back in 2015 in the wake of the Zimmerman trial. In Florida, you can defend yourself anywhere you have a legal right to be. Take a listen to the former governor.
In Florida, you can defend yourself anywhere you have a legal right to be if you reasonably believe you're in danger of death or injury or rape or kidnapping. This is a sensible law that other states have adopted because you shouldn't have to choose between being attacked or going to jail.
So it's an ongoing issue. It's been playing out in Florida for a while. Philip, is this a unique place to see it playing out, and will it have ramifications across the country as the discussion continues?
Oh, no, this is absolutely nothing new. There are, I think, 24 states that have so-called stand your ground laws of some form or another. But traditionally, at common law, the notion of the personal individual right of self-defense goes back centuries. It goes back to Old English common law. Some jurisdictions required that if a person had a reasonable avenue of retreat, they must exercise that avenue of retreat before they would be entitled to use deadly force. Other jurisdictions said no, there was no duty to retreat. So what's happened is states have basically made their own individual decisions that either you do or you do not have an obligation to try to retreat if you believe that your life is in danger. Florida made the decision that said, look, we don't have a duty to retreat. And in the Zimmerman case, for example, that case was not even tried under the stand your ground law at all. It was traditional self-defense, because as whether you agree with the verdict or not is irrelevant for this discussion. But basically what it was decided in that case was that there was no avenue of retreat anyway, and therefore stand your ground didn't even come into play.
It is certainly one to watch. Sorry, Wendy, we're running out of time, but Wendy, Patrick, Philip Holloway, thank you so much for joining us. Happy 4th to you both.
Happy 4th.
Thank you. Happy 4th.